we move on to look at the third role of the judiciary. Recall that we looked at the first one that says that the judiciary is constituted as the ultimate interpreter of the Constitution. And the second one we have discussed so far is that the judiciary ensures that the exercise of power by other arms or organs of government is in accordance and in compliance with the requirement of rule of law. The third one we are looking at is that the judiciary of the three arms of government only has the competence to supervise and review the action of the other two. The judiciary, out of the three arms of government, has the powers or the competence to supervise and review the actions of the other arms of government, and where necessary can declare null and void any action that they may embark on that is contrary to the rule of law. It can declare what? Declare null and void, that is to make it of no effect. If either the executive should do something that is not in accordance with the rule of law, the judiciary can invalidate it. That's what we mean by declare it null and void. Now, in this case, let me give you the case, even though you often are so much interested in hearing cases in this class. In the case of Attorney General of Bender State versus Attorney General of the Federation, I said in the case of Attorney General of Bender State and Attorney General of the Federation and 22 others, this then Chief Justice of Nigeria, Fatai Williams, has this to say. Are you with me now? Attorney General of Bender State versus Attorney General of the Federation and 22 others. Oh, you don't know how to spell attorney. I know that's why you are saying you are not with me. Let me spell it for you. A-T-T-O-R-N-E-Y. You should be able to spell general. You cannot. Okay, I will spell it for you too because I'm in a good mood. General of Bender State. Of course, some of you may not know it, that we used to have a state called Bender State. You may not know. All right. Now, this is what my Lord Fatai Williams said, and I quote. Justice Fatai Williams said, and I quote, "Courts of law in Nigeria have the power and indeed the duty to see to it that there is no infraction of the exercise of legislative powers." I'll repeat again. My Lord Fatai Williams, CJN, then said, courts of law in Nigeria have the power and indeed the duty to see to it that there is no infraction of the exercise of legislative power, whether substantive or procedural, as laid down in the relevant provisions of the Constitution. I'll repeat that again. Court of law in Nigeria have the power and indeed the duty to see to it that there is no infraction of the exercise of legislative power, whether substantive or procedural, as laid down in the relevant provision of the Constitution. Now, what was the court saying in that place? It was talking to the legislative arm that this court of law, by virtue of the power that has been vested in it, will not allow the legislative arm to do what they like, but that they must follow strictly the provision as laid down in whatever law that they are dealing with, either in the Constitution or whichever they are dealing with at that time. Rule number 4 of the judiciary. Rule number 4 of the judiciary. The judiciary adjudicates on dispute between states. The judiciary does what? Adjudicates. You want me to spell adjudicates? If you have spelled it right? Yes. Alright, that's good. The judiciary adjudicates on disputes between states, between states and individuals. Between individuals and corporations or corporate entities. So that still talks about all that we have been saying. That when there is dispute between government and the citizen, it's the judiciary who will adjudicate, who will serve as the unbiased arbiter. Or when there is dispute between two individuals, Mr. A and Mr. B, or Mr. A and MTN Nigeria Limited, or Mr. B and Globalcom, or whichever entity. So far we have discussed about the 4 roles of the judiciary, right? The first one is what? Number 2? Number 3? All right. Number 4? Number 5? You don't got the number 5. All right. So we'll rest on the 4 roles that we have discussed, and every other one may be subsumed into the 4. But the 4 already captures all that we need to know about the role of the judiciary. Now, it's important for us to look at or to note the distinctions between judicial functions and judicial powers. What did I say? We look at the distinction between judicial functions and judicial power. Now, I said earlier, based on the definition of Black's Law Dictionary 9th edition, that judicial power is defined as the authority that is vested in the courts and judges to hear and decide cases and to make binding judgment on what? On them. I also said in that definition that the power to construe and apply the law when controversies arise over what has been done or not done underneath. That definition is still relevant to the discussion we want to have. Now, the function of the judiciary encompasses the role of the judiciary in resolving conflict. Okay? The function of the judiciary encompasses the role of the judiciary in resolving conflict through established rules. You know, we have just talked generally about the fact that they adjudicate between two individuals. Now, what we have added to it under this subtopic of the distinction between judicial power and judicial function is that the judicial function, or as the judiciary, resolve all these disputes through established rules. And these rules can be exercised by non-judicial or quasi-judicial institutions. I said these powers or this function can be exercised by non-judicial or quasi-judicial institutions. You know, we have the courts, right? Before you get to the courts, if you are in an allegation of crime on an individual, usually the police will do what? We make arrest. And the police is an essential part of the system. We make arrest, or when there is more like a dispute between two individuals and has led to maybe some form of fight, and then the police is called in, they begin to exercise such power as to restrain the two individuals from continuing in that fight. They make arrest and temporarily detain them while they carry out investigation. So that function also lies, or at the end of the day, if they go to court, the court will make some form of final judgment if the matter should go through the entire remaining process. But what we are saying is that that function of that judiciary is based on established rules. That's why we say that there are some things that the police cannot do. For example, if they want to search your apartment, it is required they come with what? A warrant. If they want to arrest you, there should be some form of, the arrest should be dignified. But what do we see all around? What do we see? What do we see? We see brutalization, we see abuse of such powers, and so on and so forth. But of course, that is not what the Nigerian police actually stands for. But the bad ones in the force will always put the police in bad lights. So, then the power is restricted to recognize judicial institutions, and it's usually much wider than the general function. The function can be exercised by judicial or quasi-judicial body. Can the police sentence somebody to jail? That authority or the power to do so lies where? In the courts, which is the judiciary. So you can see the function now You can also see the exercise of what? For those that have ears, let them hear what the Spirit is saying to the church. So, it should see to where? No, I've said it now. Okay, where do you think the power is? Because I've said it here. It's where? To the courts, which is what? The judiciary. And that is to say that only the court can exercise some certain power, even though the function to adjudicate between can be carried out by coercive, that is semi-judicial bodies. You hear maybe tribunal, you hear some mobile, whatever, and all of that, but not the full-fledged court. Okay. Now, like we said earlier, in Nigeria, for instance, the power of the judiciary are contained in Section 6 of the Constitution of the Federal Republic of Nigeria. So the judicial power vested in the according with the provision of that's what the section says, that judicial power vested in accordance with the foregoing provision of this section. It now lists the sections, the subsections. Okay, that A shall extend, notwithstanding anything to the contrary in this constitution, to all inherent powers and sanction of courts of law. It comes back to what we were saying, that yes, some people may exercise that function, but that power is exercised by where? By who? By the courts. But in all of this, that power is one way or the other caged within the court in order to prevent abuse. Because if let's say the police, for example, or other governmental agencies do have the power to sentence people to jail without the court, there will be abuse, series of abuse. Even when they don't still have that power, people still languish in our police cells without lawful reasons. Okay? All right. So, lastly, before we call it a day here, we look at the distinction between judicial power, judicial function, and jurisdiction. Okay? That is the third word that is introduced, that is different from what you've been hearing so far. Am I not correct? Yes. Okay. We already know what judicial power stands for. Judicial power or function refers to judicial capacity of an institution. On the other way around, jurisdiction refers to the capacity of an institution to exercise its powers in relation to a particular subject matter or person. I'll repeat that again. That jurisdiction refers to the capacity of an institution to exercise its powers in relation to a particular subject matter or person. Meaning that if the police can have power to arrest, to prevent breakdown of law and order, the police cannot hear the matter and give a judgment. Do you understand? So there is limitation to the exercise of the power, and then there is like the fact that the jurisdictional part of it is very crucial, and then it is not all those who can exercise judicial function that can exercise the jurisdiction. Okay, well, I wanted to do something from now. No, I want you to try that. That is all right. 5 seconds. Okay, so sorry for that break. So that is what we are saying, that the institution may have judicial powers but may not have the jurisdiction to hear or determine the matter. Let me give you an example, as I have here in my jottings. Section 232 sub 1 of Nigerian Constitution. I want to show you something before I close. Section 232 sub 1 of the Constitution of the Federal Republic of Nigeria confers on the Supreme Court original jurisdiction in any dispute between the federal and the state governments. Okay, I'll repeat that again. That section 232 sub 1 of our Constitution, 1999 Constitution, confers on the Supreme Court original jurisdiction in any dispute between the Federation and a state, or between a state and another, as long as it pertains to determination of legal rights. Legal rights. So what we are saying is that, you know that every court in Nigeria, they perform the function of judiciary, right? But we are saying that there are some courts who have what we call original jurisdiction, in that is where the case must start. For example, when there is dispute between federal government and states, you cannot take it to high courts. Are you following me? It has to start from the Supreme Court. Because which state do you want to take it to? Which state do you want to take federal government to? The state may likely favor the other state that is involved in the matter, as against what? The federal government. That may be the whatever reason behind it, but what we are saying is that is an example of what we are saying when we're talking about jurisdiction. Meaning that any case that has to do with federal government and state government, we have its original jurisdiction in the Supreme Court of Nigeria. So, therefore, you see that the matter of jurisdiction is also another point to consider. Let me give you another example. In Nigeria, the Supreme Court is the highest court, right? Yes. Followed by the Court of Appeal. Now, when there is a judgment at the Court of Appeal level and a party is not satisfied, the party cannot go to High Court. It has to go to where? Because it is the Supreme Court that carries the power and jurisdiction to hear such matters. Just like when you have an issue with maybe you have written a particular exam and your result was not released. Do you write to the Vice Chancellor? Who do you write to? You probably write to the course lecturer, either through the HOD. It is only when those people are not able to resolve it that you take it to the dean, from the dean, either to the Vice Chancellor, as the case may be. So, what we are trying to talk about there is that the hierarchy. As a lecturer, there are some things I can do, and there are some things that I cannot do. It has to either be my HOD or my dean, and so on and so forth. So, if we are saying that, yes, all of us as lecturers, as officers of the university, we have power to do some things, but there's a limit to what we can do. That's what we are trying to explain here. So, in summary of all that we have been saying, the role and function of the judiciary includes but are not limited to the following. We have already talked about all of them. As I conclude, I will list them, then we bring the class to a close. Number 1, interpreting and applying the law. Number 2, resolving conflicts between persons, both natural and juridical or artificial. Number 3, resolving conflict between government institutions and citizens, and between citizens and institutions. All of this we have said before. We just recapping. Number 4, the judiciary ensures the constitutionality and legality of government activities. It ensures the constitutionality and legality of government activities. Number 5 is that it protects the rights of citizens against abuse. All of these we've discussed in the course of this class. So, what you should know, therefore, is that judiciary as an arm of government plays a very cardinal role in the administration of justice in our country, and it helps to manage every part of the society as it relates to whether our actions are in line with the rule of law or the required process as provided under the law. So with this, we'll call it a day here. But I just need to mention that you have to go and read up this topic again, because it's not possible that your lecturer will give you all that you need to know on the subject. So I'll take questions if there are any before we bring the class to a close. Any question? Yes, please. Can you speak out? Yes. Yes. Hello, class. Can you listen? Somebody is asking a question now. You are not listening. How do you learn? Yes, then go ahead. Yeah. Yes, what we mean by, we didn't say that the judiciary in the application, when you come to a court of law, they interpret and apply to what is needed. It's different from execution, as in carrying out what the law says outside. Do you understand? But they give the meaning and apply it to the cases before it, so that arrive as the best judgment or justice for individual. Any other question? Any other question? All right, so we call it a day here, and like I said before, go through your textbooks to cover up for whatever we may not have been able to explain to you in the course of this class. So with that, we bring the class to a close. See you next time and enjoy the rest of your day. Bye.